um, had cause to give reasons for why the apex court, the Supreme Court of the land, needs more justices to fill up the bench. There's a call for 5 more justices to join the Supreme Court bench to make it 20 from the current number of 15. She says there are a lot of cases that are coming up. There are a lot of cases that they have to deal with. The case management requires that they need more hands at the apex court. What do you make of the reasoning behind increasing the number of Supreme Court justices that the country has?
Thank you. First of all, I would like to say increase.
Sorry, the connection is a little choppy, so I would kindly ask that if you could kindly reposition for us and see if the connection can be much better. Hello, sir. Can you hear me? Hello, Mr. Sari. Mr. Ansar Sari, can you hear me? Let's try one more time. Can you hear me, sir? Okay. Emmanuel, kindly recall him, and let's see if we can get a clearer connection through to the former director of the Ghana School of Law and private legal practitioner, Mr. Ansar Sari. Want to pick his thoughts on the reasoning that's been given by the Chief Justice as to why the country needs more Supreme Court justices. We do know that in May of this year, a request was made relative to the request for more Supreme Court justices. Let's retry, Mr. Sassari. Chief, can you hear me?
Yes, I can hear you.
Much clearer now. Yes. So I was asking whether you see the logic and the reasoning for the increase in the number of Supreme Court justices as is being requested by the Chief Justice.
Okay, and the first point I was making was that the Chief Justice by herself has no power to increase the number. So I should like to believe that the request emanated from the Judicial Council, of which the Chief Justice is chair. But having said that, I don't think the reasons assigned by the Lord Chief Justice are convincing. I've said it before that in the U.S., with a much larger, population and a bigger country, the USA has 9 justices. They've had this number since the evolution of their constitutional democratic system. We have a much smaller, population and a much, smaller nation. As I said, the size of Ghana is like the size of Oregon in the U.S. So, convincingly, I don't think that we have any cause to. However, I would like to believe that the number keeps increasing. This year is an election year, and the objective conditions of the ground suggest that it could go either way. I should like to believe that any increase in the number of justices of the Supreme Court is an attempt to pack the court should the election go against the NPP, and therefore, should there be a challenge, then the number to be drawn from, and I believe, I stand to correction, that the panel will be drawn from the favorites. Mind you, those who are likely to be elevated must be favorites of one or the other person in power. I know that the GDA has issued a statement that in the court there's no NDC or NPP, but common sense will tell us that each time an incumbent government makes an appointment, the appointees suck up government. So we shouldn't run away from this objective fact. It is an attempt to pack the court in December or January or March when electoral petitions are being judicially considered by the apex court. And I think that it is something that the government ought not to have orchestrated at all. We want peace and stability in this country. Now, secondly, if the legal chief justice, as chair of the Judicial Council, is trying to assign, alternative reasons as to why the Supreme Court, should be increased from its current strength of 15 to 20, I mean, it's mind-boggling. What are they going to do? Thirdly, from the rumor, vine, I understand, that the fight includes, some judges who are currently sitting on very sensitive political matters. Again, commonsensically, this should not be done at all. If a justice of any of our superior courts is sitting on, a political or politically sensitive case, that judge ought not to be elevated at all. Because once the elevation is carried through, should the decision go against the accused person, those that they were convicted not on the merits of the case, but because government had an interest in it. So I would think that this is not the time, for the government using the Judicial Council, merely using the Judicial Council as a cover-up. And the Judicial Council ought not, to have entertained the request at all in the first place. So candidly, I don't think that any justification or any reasons can be justified. No justification can be given. We don't need the Supreme Court justice. We don't need him. The Constitution in Article 128, Clause 4 is quite clear that the Chief Justice plus 9 other justices, even though there's no capping, I think that a reasonable interpretation will suggest that the 10 is okay for now.
Hearing the Chief Justice yesterday. Okay, but hearing the Chief Justice yesterday, and to quote her directly, she says, the ruling is adjourned to 17 July 2024. We must thank everyone for their patience, but this is our lot. There are several cases pending, right? That is why we need more Supreme Court judges. Is it a case of case management not being done well? As a reason for which the load for the Supreme Court justices are becoming a lot, and the call then for more to be added to the bench?
My brother, honestly, it is a case of winner takes all. And therefore, the incumbent NPP government is just looking for ways and means of finding jobs. If there should be any promotion at all, it should be on basis of seniority. What we witnessed so far under the current Akufo-Addo led NPP government is that justices are being elevated from the bottom of the ladder, so it's bottom up. You see, and I believe that some time ago I said that I can only hope that the appointment of the current Chief Justice will be the last in the line of young justices being elevated to the highest position. And I maintain, I will not change my position on this matter at all. If the executive is afraid of his own shadow, so be it. But I would think that none of our government to use the judiciary as an instrument of oppression. It is not good for the country, it is not good for our image, and it's not good for all of us. I think the reasons that are being given now, look like finding, a stick to beat one dog. We should not, entertain such things. I mean, is the lady chief justice suggesting that each time we have, a very sensitive case, the number should be increased? For me, it's an illegitimate extension of abuse of power.
So should the Chief Justice withdraw this request?
I'm telling you that knowing, the system intimately, this is not the Chief Justice who is doing it. I don't think the request is coming from the Chief Justice. As I said, if the request must come at all, the Judicial Secretary should be the mouthpiece, to announce whatever changes they want to make for and on behalf of the Judicial Council, and let us leave the Chief Justice out of this mess. It is a mess. We are creating, problems in search of solutions. We don't need any such thing. Even if they were to add one more, it is still illegitimate. Clear abuse of power, clear abuse of incumbency, but the problem that will loom large will be when we know the outcome of the elections. As I said, if it goes against the NPP, then they will have solace, or they will find solace in the parking of the court. This happened during the Rawlings regime, and my sincere and honest assessment of the situation is that whatever the numbers will be, it will be intended to use them to claim victory. And it is not good for the country. It is not good for our image. Nkrumah did it in the 60s. And if he were alive today, I think that, he would be the first to regret, to have done that. Nanado should be wiser in this as a lawyer. I'm sorry, but attempt to bastardize and politicize the judiciary should stop. We have Article 127 guaranteeing the independence of the judiciary, and anything we do ought to derive from the protection enacted or the independence enacted in Article 127 of the Constitution of the Republic of Ghana. It accords with common sense. It accords with protection of the liberty of the citizen. And it accords with the protection of the justices themselves. Today, our judges are timorous. They are timorous because they do not know what is likely to be their fate the next morning, and therefore they have to kowtow to the wishes of the government in power. I am not suggesting that this is peculiar to the NPP government. It has been used by the NDC. It was used by the CPP. It has been used by the various military juntas we have had in this country. The end must come one day. We need to stop it. And if there was any time to bring this to an end, the time is now. I would suggest strongly to the Judicial Council not to entertain the request at all. And if they have acceded to it, Nothing prevents them from going ahead. I don't think Parliament, can rise up to the occasion and refuse for once to vet them. I don't support it at all, and I'm afraid. I'm afraid that there is only one reasonable expectation coming from whichever quarter is behind this thing. Pack the court. Thank you.
All right. I thank you so much, sir, for your time and for joining us. Oh, before I let you go, the Speaker has also mentioned that in spite of all that we are seeing happening relative to the anti-gay bill, no court can direct Parliament on how to do. No court can stop Parliament from doing its work until the process is completed. For you, is the Speaker right in his assessment on this matter that no court can stop Parliament from doing its work when a process for a bill is in motion?
I support the Speaker 100%. Ours is a democratic government, and we practice separation of powers. And the powers of government, the three branches, are clearly separated. If you go to the Articles 57 and 58, you find the executive clearly delineated. The legislature from Article 93, and legislative power is vested pursuant to Article 93, Clause 2 in the legislature. And when it comes to judicial matters, Article 125. So the lines are clearly delineated. Each branch is a law unto itself. The court cannot regulate the parliamentary processes residing in Parliament. It's a no-go area for the court. Once the legislators have spoken, that is it. However, the final arbiter is the court. And therefore, concerning issues of want of jurisdiction or excess of jurisdiction in the lawmaking process, the court will be the last to be called upon to intervene. So what the Speaker said is the law. That is it. In a system that practices separation of powers, each branch is separate and distinct, subject to the desired checks and balances.
All right, sir. Thank you so much for your time and for joining us. We're grateful.
Thank you.
That's Mr. Starr. He's the former director of the Ghana School of Law and private legal practitioner, sharing his thoughts with us on the request by the Judicial Council to the President for additional Supreme Court justices to be appointed. The Speaker, Albert Sumana Kingsford-Wagon, has been speaking on the work that Parliament has to do and the fact that when a bill is in motion, no court can stop it, and other matters. Let's hear him, and then we'll pick some other perspectives on the very same matter here on the show.
Now we can expect that it will stand. It will fall. It will fall. One, the issue you raised, if anybody is minded to take it up, it is the enabling act that the person can take up to court. That enabling act. As to the draft subsidiary legislation or delegated legislation that is purported to have been issued or made by whatever authority is not known in law until it is processed and passed by this House. The challenge we have is the Article 11. And that is what I stated earlier on. Because we have mixed the concept in our constitution. The concept of the representation of the member of parliament. When you want the member of parliament to be focused on plenary sessions, you don't want the same member of parliament to be at the constituency all the time, so he can focus on that. And that's why I usually refer to you people to look at the mandate of the MP. If the MP is always expected to be at the constituency all the time, he cannot be on the floor. So when you are looking for percentage of the presence of MPs in the House, and you put it at 2/3, it means you are saying that the MPs should not be at the constituency. Or when you put a provision in the Constitution, and members should be guided by this. When you say that a member cannot absent himself continuously without the permission of the Speaker for 15 days, in other words, you are saying the member should be focused on the plenary session. Meanwhile, in practice, the constituents expect the members to be present in the constituency on a daily basis. And so the two cannot work together. So the percentage of 2/3 is so high that it cannot be met. In fact, in practical terms, it's not only the constituency. We know the number of times that MPs are called outside even the jurisdiction of this House, or even in the oversight responsibility of this House. Members are constantly in other areas inquiring into activities of ministries and departments to report to the House. So they cannot be on the floor of the House at the same time. And so anytime you try to get this, before we started the Bagwis doctrine, it was because of this. I had to mobilize as the chairman of the subsidiary legislation to get a large numbers of members on the floor to support me to annul that instrument. That instrument also came from the same Ministry of Trade and Industry. And the members were present, and I differed from the position of the committee, which I chaired, and assigned the report. But on the floor, I sought the permission of the then Speaker, Right Honorable Daniel Francis Annan, to disagree with what the committee has stated, which he permitted. And I managed to convince the House that that instrument had no legal basis. And the House agreed, and we annulled it. And that raised a problem in government. At least there were some reprisals. And I myself was seen differently by the then government to which I belong. You see, so these are lessons we learned. And that is why in bringing the instruments, I say the sponsoring authorities should always make sure that they comply with the law and get the House to have some inputs, come to consensus before it is laid. Now that this one has been laid, and you are still raising issues on it, I don't know what we can do apart from the advice I gave. If the minister agrees to the guidance and advice, they will come and do the right thing. If they don't agree, then this House, we are having a serious challenge. But after that, one can take action legally on it. After it passes through, a member can take the matter to court. And that one, the member will be properly grounded in law to do so. That is the only time any person, not only member of parliament, any person will take that instrument to court, and the court will have jurisdiction to listen to it. But I'm saying that until we finalize the process, whether subsidiary legislation or an enabling act, nobody has any basis in law for taking that to the court and calling on even the Supreme Court or whatever to deliberate on it. The court has no jurisdiction. This is our arena. I don't want any rate to come to me again, considering things we are dealing with, particularly legislation. That's why I'm saying this, and I hope that the media will carry it. Please, can we now conclude?
Okay, so that's Speaker Alban Sumanaki Sobam. We can speak now to Justice Abdullah. He's a paralegal practitioner and a law lecturer. Chief, good morning. Always a pleasure. I trust you're well and keeping safe, sir.
God is good always. Thank you so much for having me.
Wonderful. First of all, we had the Chief Justice yesterday at the close of the matter, including the anti-gay bill that's before the Apex Court, mentioned that the date for the next sitting had been adjourned to 17 July and said that she's thankful for everybody's patience, but that's the very reason why they need more Supreme Court justices for case management purposes and other matters. For you, is there a feasible or plausible case for why Ghana needs more Supreme Court justices?
In fairness, Francis, I would say that we don't just need Supreme Court justices. We need several personnel within the entire chain of our adjudication bodies, and indeed legal practitioners. We fall short of all these personnel right from the lowest level. The courts are all inundated because of lack of personnel. So we do not have enough lawyers, first of all, particularly for the state agencies. The Attorney General's office is highly understaffed, particularly within the regions. And so if you go to the 5 northern regions, for instance, you probably will not even find up to 10 lawyers in the whole region. In fact, the entire 5 northern regions put together, I don't think you can even find up to 20 lawyers for the entire 5 northern regions. If you go to the other regions, the story is not any different. Similarly, if you come to the courts, from the lowest court being the district court to the highest court are all understaffed, and so the courts are all inundated with cases. Some courts have as much as 500 cases, some as much as 1,000 cases, particularly at the lowest level. And in fact, it is because of this that the current Chief Justice actually had to roll out the evening courts, or if you want to call it the afternoon courts. And so we have more like the 3 senior high, where you have the morning sessions and then the afternoon sessions, just to ensure that some of the cases, our cases go speedily and all of that. So if you take that into consideration, then absolutely yes. Now, if you go specific to the Supreme Court, we have a special Supreme Court that is in charge of almost everything that other Supreme Courts are not in charge of. So if you go to other courts like Kenya, other countries like Kenya, and I think South Africa, they do have the Constitutional Court. In fact, I think France also has a similar thing. Constitutional Court that are purely in charge of determining constitutional matters. And so these cases may not necessarily go to the Supreme Court, thereby relieving the Supreme Court of these additional burdens. In our case, every constitutional matter automatically has to go to the Supreme Court, automatically. Then you have to deal with matters on appeal, which usually could travel all the way to the Supreme Court without any limitation. The only limitation possibly be a case that commences from the district court. Even that one, if you have a special leave, you can still go to the Supreme Court. Then you have other cases, like election petition cases. You have a host of other matters that only the Supreme Court would have an original jurisdiction, and of course the other ones that they have an appellate jurisdiction. So put together, what you find is that our Supreme Court is flooded with cases. So if you ask me whether there is a need for more justices at the Supreme Court, my answer is an affirmative yes. But that answer also extends to other levels of the court, as I've indicated earlier, from the lowest to the Supreme Court. We need more people there. And as I said, we need more lawyers. And we are training a lot of lawyers at these days. We have a lot of lawyers around. The last counts, we probably would have in Ghana around 8,000 lawyers now. We're hitting 9,000. I'm sure by next year, considering the number of people who might be called to the bar come November, we probably may be able to hit about 10,000 as the total number of lawyers in Ghana. Of course, some are dead and others are in other fields. But we still have good number of lawyers that can be trained appropriately and be roped into these other parts of our justice delivery system to ensure a speedy adjudication of matters. Of course, but the availability of lawyers necessarily or judges does not necessarily cure most of our wrongs, particularly when we have to deal with delays and unnecessary delays, if I have to put it that way. Because I think that we can roll out the IT systems and not necessarily having to build a lot of bricks to accommodate courts. We can have judges probably sitting in chambers and online adjudication of matters and all of that. So there are a lot of ways that can complement each other to relieve all of us of the burden and the burden that we go through just to ensure justice for the innocent and indeed for those who deserve it. So, Francis, yes, we do need judges.
I've heard some who make the argument that the Supreme Court of the United States, even with a population of over 150 million, have 9 Supreme Court justices. Why do we need more than 15 for Ghana that has a population of 30 million? Do you see the logic behind that reasoning?
Yes, I do. Except that the logic behind that reasoning has not taken into consideration our peculiar circumstances. And I think all observers know the peculiar differences between the United States and Ghana. And I think this issue has also been overflocked. But just for the purpose of reiterating and emphasizing this same position, the Supreme Court of the United States is completely different from the Supreme Court of Ghana in a lot of ways. So they can do the 9, even with a population of 500 million, assuming their population doubled. You cannot just walk up and go to the Supreme Court of the United States. See, they have 2 different levels because they have the federal system. They have the state Supreme Court. We don't have anything like that. Each state has an apex court where a matter that commences there can end there automatically. So before you can go to the federal Supreme Court, you go through a lot of sieving, in fact, maybe 1% or even less of the cases end up at the Supreme Court of the United States. Less than 1% if my statistics are right. And we don't have that here. Here, every case is as of right. As of right, you can simply just walk to the Supreme Court with no limitations whatsoever. The Supreme Court of the United States, you cannot do that. You can't even think of going there. As a matter of fact, it's a victory in itself just finding your case on the list of the cases at the Supreme Court of the United States. It is a victory in itself, without necessarily having to determine even the matter on its merit. Just the fact that it has found its way there, it's good enough for anyone to celebrate. Because it's unusual. It is unusual. So if you juxtapose these two, you can definitely appreciate why we would need more. Otherwise, if the argument is that we do not need more, then we would have to find a way of limiting the number of cases that come to the Supreme Court of Ghana.
So one of 2 things: limit the number of cases or increase the number of judges. But even if we are to increase, should there be a capping to the number?
That I would definitely support, considering the view that if we do not...
Justice, I lost you for a few seconds there. Sorry?
President, my position is that we will definitely need a limit on the numbers at the Supreme Court. And we do because, in particular, of the conduct of this government. the conduct of this government has shown that, and I say this, without any prejudice. If you've noticed, since the beginning of Ghana, we have never had any government that has appointed more Supreme Court judges than this government. Whether for mischievous reasons or for a good reason, a good cause, it shows one thing, that the person to increase the number of judges at the Supreme Court, if not regulated, could be used as a tool to achieve an unjustified end. Because these are appointments that should be made reservedly, or at least with some serious consultations, nationwide, stakeholders engagement, for all of us to dialogue and see the need, just as we are doing with this particular subject. At least we could all accept that going forward we need a number of judges across levels, Supreme Court inclusive. But where it becomes a tool to achieve some political end or some other objective that may not necessarily be wrongful in law, but naturally wrong to the extent that the objective for those appointments are not in line with the objective of the law regulating all of us, then there's indeed a foul play and there's a reason to be alarmed. So that becomes a basis for us to regulate the appointment to the Supreme Court, in particular, in capping it, so we don't have people who just use it unjustifiably.
We now have 15. There's a case of 5 more to 20. Should we cap it at 20 or keep it at 15?
That is a question that would be difficult for me or for anyone to answer. It could be 50 or it could be more. So could it be less? But I think it has to be a well-researched, well-purposed decision, so that you don't just randomly choose a number and fix it at that point. There must be a basis in fixing it at a particular number without necessarily having to just guess and without taking into consideration the peculiar needs of Ghana. I would love a position where, for instance,
yes,
we have, the apex court has, let's say, maximum of about 9. I would love we have, say, 18. 18 being 2, so maybe 27, so that we have 3. At least at every point in time, we could have 3, and so that at every point in time, we could have at least 2 certain. Because of course, some people may be ill at the time a case is being heard, and so you can have a reserved judge to sit in, and all of that. So if you can have 3 maximum sets of 9 each, making 27, I would be more favorable to support that decision. And with these 3 sets, I would push forward for 2 to sit at the same time always.
At the minute, we have 15.
Yes, but I don't think that is enough. I think 27 will be a good number. Based on what I just said.
27. Okay.
And that 27 takes into consideration a maximum of 9 sitting at a time. Even though usually we have 7, for a review, usually. But I'm saying 9 because there could be a possible review of a review decision.
Okay. And would that also be subject to the country's ability to take care of them?
Well, we take care of 110, 120 ministers. Why not 27 judges?
Even 120 that you mentioned, there's been a big call to cut it down considerably.
Because it's a waste. But 27 Supreme Court judges, I don't consider that as a waste.
Some argue that will also be a waste.
That's exactly what I just said. At least the Supreme Court, we know what they do. With 20 more ministers, I don't know what they do. Complete waste. And this is also because, of course, we have seen that 64 have done the same thing and even better than what 123 have done. And so the 123 cannot be justified when relative to what 64 did.
You mentioned two ends of the stick in this analysis. The bit of the case that we have and the number of judges that we need, or look to the American system and how things run, where it's a very limited number at the very top, but the cases that go there are extremely, extremely managed. Can we look at the other side of the coin as well? How can we practically make that happen?
Well, that would require constitutional amendments because ours is a constitutional rule that has opened that kind of floodgate for everyone to enter. And so the possibility of achieving that end would mean some constitutional amendment.
From a purely cost perspective, will that not be a better one, considering where we are now?
I wouldn't call it a better one, but I would probably call it more maybe an economic. It probably would achieve an economic end, but to call it a better one, I don't think without any proper research, it would be appropriate to call it so, relative to the other side.
Okay. The Speaker has also had cause to mention that when a bill in the House of Parliament is in motion, no court of the land can stop them from doing their job. From a purely legal perspective, does this position hold sway?
Indeed, it's been part of our constitutional jurisprudence, and that is actually the fundamental law that the activities of Parliament is a closed book to any other organ of the state, in particular the judiciary, and so the judiciary cannot enter into how Parliament undertakes its activities and all of that. And this was affirmed by the Supreme Court in the Justice Abdullahi versus Attorney General case, and all the other cases prior to that.
Sorry, when you mention that case, you are referring to you, correct?
Yes.
Justice Abdullahi is you. Yes. Okay.
Yeah, I'm referring to me.
Yes.
In this particular case.
Okay.
And then indeed the other cases before that, that's before an Attorney General. And interestingly, before an Attorney General, the current president was the lawyer, one of the lawyers in that matter. And so these are cases that have affirmed our constitutional rule. And there are several other authorities, affirming this position, that the activities of Parliament is a closed book to the judiciary and indeed to all other organs. And until the decision is finally out, whatever decision that comes out can be questioned by the court, of course, because our constitution does not have a supreme parliament as pertains in the United Kingdom. We have a Supreme Court, and so our Supreme Court can question every decision of everyone and anyone. But what they cannot do is to enter into the inner corridors of Parliament to interrogate what they do and how they do what they do. That they cannot do. So, on the basis of that, I agree with the Speaker when it comes to that position. So, unless a decision finally arrives from Parliament, the Supreme Court doesn't have any authority to interrogate it. But if we are to relate that to the case in court, I think it will be a different thing. We may not be able to comment on that until the Supreme Court comes out. But the only flesh I probably may add to that is that whether one considers a bill as passed by Parliament, because in this particular case you are talking about an LGBT bill that has already passed from Parliament. It's not yet an act. So it's not yet an act. Neither is it technically it's still a bill until the President assents to it. But is it a decision of Parliament or not? I think that is where the Supreme Court would help us in appreciating and possibly get around this matter.
All right. Justice Abdullahi, I thank you so much for your time this morning and for joining us.
It's for God and country always.
Thank you, sir. Justice Abdullahi is a private practitioner and a law lecturer joining us with his thoughts there. Time check, 8:30. This is Morning Star. We're live here on the Crown Star 103.5 FM. We're also live on Ultimate FM in Kumasi, live on Empire FM in Sekondi Takrady. Around the world, we're live at starfm.com.gh. Let me go for a short break now. When I return, there's a question we need to answer for our random conversation, and it's this. What is it with our fixation, or should I say our love, to be recognized? Yes, to be recognized for an achievement, for doing something great. And what does the lack of it do to us? Case in point, I'm sure you guessed it, Chef Smith. But there's been many before that. We'll discuss that this morning for our conversation here on the Morning Star. We're back after the break. Stay with us.
Life is a stage, and we're